Okay, today is not July 8th, but today we are going to be talking about Form 35, the inspection contingency. And in our class today, we're going to talk about why a buyer should perform an inspection, why why it also protects the seller to allow them this inspection, who can do the inspection, what happens in the event that the buyer acts as their own inspector. And are you required to deliver the inspection report? How do we trigger initial or additional inspections? And why even use this to begin with? So why does it matter whether a buyer does or does not have an inspection? Well, in Washington state, we are technically what they call a buyer beware state. And what this means is the weight of responsibility is on the shoulders of the buyer to do all the research and find all the information needed in order to move forward in a home sale. So if we deny the buyer the right to do this, then what we are basically doing is stripping them of the only obligation and right they have as a buyer and essentially putting that risk back on the seller for disclosing everything that they should be disclosing. So why have an inspection contingency? Well, there are several reasons that we may want our client to have the opportunity for this inspection. So we do need to remember, once we have mutual acceptance, we are done with the right to access the home is no longer there unless we create that right with this form. So one of the reasons we may have access to the home other than having one of these is with maybe a financing contingency or an appraisal contingency, or somehow with the 22EF, if there is a lender, that lender would be allowed access to the home. But unfortunately, the buyer's access to the home ends after there is no inspection contingency that allows the buyer to get in there. So it is possible that a buyer could follow a lender in to any of those required inspections that a lender has. But in short, there's not going to be a contingency out for that buyer if they were to discover anything during those inspections. So at that point, the buyer is basically at the mercy of whatever the lender calls out or does not call out. If your buyer is interested in seeing the home after mutual acceptance, such as, for any other reason, maybe they're just really excited and they want to see it again. Maybe they want to take measurements. Maybe they want to do an inspection and create this sort of contingency out based on what they find. They have no right to do so unless they have the Form 35. Including the Form 35 is your buyer's get out of jail free card. So they can choose to do an inspection or not. They can choose to purchase after this inspection, or they can terminate, whatever they choose. So this part of the contract gives the buyer the right to make that decision and, if necessary, retain their earnest money. So during the initial inspection period, who can do the inspection? Well, this inspection period is going to be where the buyer can come in and bring their licensed home inspector, a plumber, a roofer, a home inspector, a mold abatement company, anybody who is considered a specialist, anybody who has a license to do what they are inspecting to do. And the buyer can also be their own inspector. So the inspection contingency itself has basically 3 sort of segments of the inspection, and potentially 4 if you check the neighborhood review contingency. First one is the sewer scoping. Now, we can look back at the form, but the first paragraph says that the buyer may or may not be allowed to do a sewer scope. Now, with the sewer scoping, that requires a line to be fed through the sewer pipes until it either reaches the end of the property line or the septic tank. So this is typically done through an access point or one of the clean out points, or potentially by removing a toilet and going down the pipes. During the home inspection, the home inspector will look at the structure, the foundation, the general systems, and many times this inspector may see things that will require further inspection by somebody in a more specified area than themselves. So these experts now, if called out, can be included in that additional initial inspection period. But if the buyer can't schedule them in time and those additional inspections are required, then the buyer can trigger their additional inspection period. The next one is the additional inspections. So these are for those experts that needed to be called out that were not necessarily brought in the initial period. So these might be call outs from that inspector on things like electrical or plumbing, or potentially they got into the attic and found mold. So that additional inspection again gets triggered when the inspector calls out the need for further inspections. Now, during the initial inspection period, the buyer is obligated to act as their own home inspector or hire a licensed home inspector. There are no other options in these two things. The takeaway is that the person performing the inspection must be licensed if they are hired on behalf of the buyer. This means that you can't have your father-in-law or a friend come in and act as your home inspector. If the buyer acts as their own home inspector, they are not able to trigger the additional inspection provision by an expert. They must do their additional inspections within that first period or hire somebody who can then suggest additional inspections later. Now, any items that are removed, some items are going to be removed. So I highlighted right here on line 9 that the buyer's general home inspection must be performed by a licensed person under the RCW. And the buyer may engage any specialists that they choose, such as plumbers, electricians, and roofers. I did mention before that the sewer inspection also may require removing toilets or removing things to access that. Now, the important part here is that by doing an inspection of any kind, a buyer is taking on the responsibility for any damage created by such inspections. Now, items that are removed, and that may include invasive inspections, are going to need written permission from the seller to be removed. This would include something like removing deck boards to access under the house, or removing a piece of drywall to look behind it if it's squishy. You cannot do those types of inspections without the written permission of the seller. Now, at this time, the seller may want to consider that these inspections that they're being asked to do will potentially cause damage. So a sewer scoping, by giving permission, we've already given permission by checking the box in line 12. So if you're a seller and you see this come through and you see that line 12 is checked, you need to be aware that they're going to be removing potentially the toilets. They're going to be removing the sewer line caps. And by doing this, are going to be removing the seals that go with them. And not all of these items can just be replaced and put right back where they were. They may need to have items repaired or replaced completely in order to keep them fully functional. By signing this form, the buyer is also acknowledging that they are going to be responsible for the damage caused by the home inspector. So whoever they hire, they need to be aware that they are responsible for the damage of that inspector. Like I said before, deck boards can be removed and be inspected, but must be replaced as they were before. And anything removed must be replaced. So like I said again, the sewer inspection requires the removal of items that have seals. Now these seals are potentially the wax seals that are underneath toilets, or even the silicone seals that keep the pipes closed and all of the fumes and liquid out of the home. So these seals must be replaced if they're removed. Make your buyer and seller aware that these inspections are invasive, and by removing this, it will require the replacement of those wax seals and potentially a licensed plumber to put it back together. There's plumber's putty in the access points. So if you're doing this, keep in mind that your home inspector may not be the type of contractor that can put these things back. If you have a plumber that's required to come back and fix these things, that damage or replacement is technically on the shoulders of the buyer. Now, damages that occur are not the same things as a buyer breach of the contract. So these things are not necessarily covered by earnest money. You can't go back and say, buyer forgot to put the wax seal back on my toilet, and now my toilet leaked and damaged my floor. That type of damage is not a contractual damage covered by earnest money. So these things need to be addressed separately from a buyer's breach of contract versus a buyer's damage. Just keep that in mind. So earnest money, like I said, is typically not addressed when it comes to a violation in a form like this. So have you ever had a buyer damage something? And have you ever had to go to the seller, or did the seller ever find damage and you had to address that with the buyer broker? Think about how those conversations have gone. I've had probably 3 of those conversations, so not a lot, but every single one of them I've had has been met with defense and a lot of not wanting to take responsibility financially for the damage. So keep these things in mind when you are talking to your seller about home inspections and as a buyer hiring a qualified home inspector. Now, contractually, you are protecting your seller by, you're protecting your seller and you're following the contract by calling out damage that you might see. And altogether, an inspection contingency is truly beneficial for both people. Sorry, I'm going to take a drink really quick. Now, the buyer has a timeline in which they need to conduct all these inspections and must have a response given to the seller within this timeline. Now, in the event no response is given by the buyer, the default response as a no response is an acceptance and a waiver of the financing contingency. So buyer, unless you come forward with a response of either a termination or asking for repairs, a non-response is an acceptance and moving forward from this. This means the buyer would be unable to ask for repairs, additional inspections, or get out based on any findings if there's no response within the date in paragraph 3. Now, there is a way to extend that general inspection contingency with the additional inspection provision, but remember that you still need to respond with this within those days. Also, additional inspections must be called out by the home inspector. And although we don't need to provide proof immediately with this, if asked, we need to be able to provide proof that the inspector did in fact call out these additional inspections. And the seller has a right to demand seeing that proof if asked. Now, at the time the seller signs the purchase and sale agreement, the seller can elect in any one of these 3 boxes to see the report in its entirety, a portion, or that any repair requests be accompanied by the report. The seller is the one that should check these boxes, and anything that gets checked in these boxes is not going to create a counter offer. Now, as proof of who selected the boxes, you are welcome to go ahead and initial these boxes if you'd like, But these boxes do not change the timeline, nor do they change mutual acceptance. And the buyer should technically not be the one selecting them. But as a seller, if you go through and you see that the buyer did select one of these boxes, if you don't agree with the box that's selected, you're going to need to cross off that and place your choice in this. Now, if any portions of the inspection report are given without the seller's consent, then the buyer has waived their inspection contingency. So this means they are waiving their right to get out and to retain earnest money based on the inspection. So please do not send any portion of the inspection report unless these boxes are checked. Now, after mutual acceptance, there is another form that we can use to consent to see the report. So once mutual acceptance has come through, go ahead and just keep the stuff moving forward here. There's a form that we can use, Form 35C. That is a form that is consent for seeing the inspection report. So once mutual, to avoid confusion, grab your 35C and select the box that applies. So now when you're selecting the additional inspections, remember not to provide a portion of the report that states that unless it's asked for the seller. Again, they do have the right to ask for this. The default time for this is 5 days. So when you're looking at the inspection contingency as a whole, we're looking at the initial inspection contingency plus potentially the additional inspection timeline. So as sellers, we could potentially at default have our home in the pending inspection for 15 days. And these could be 15 calendar days or 15, not calendar days because of how things lie. So those timelines are pretty wide. Just timelines to keep in mind. Don't forget about both parts of the inspection contingency. Now, once a response is given, neither party can interfere with the timeline of that response. No one can redact their response. No one can rush the other party to reply. The buyer gives a response and must wait for that seller to respond. Now, our default is 3 days. So when I talk about this, I'm going to go off of the default. If you do anything other than the default, be aware that those timelines come very quickly. So the inspection response should be done on the Form 35R. This form is designed to reply to those timelines to be directly connected to the inspection contingency. The buyer gives notice and the seller does not respond by that 3rd day. So paragraph A here, buyer gave notice. Now seller has had that response and on the 3rd day has not replied. Well, that non-reply for the seller is a reply. So by the 3rd day, if you don't have a written response, then you do have a response from the seller that is a rejection of whatever the buyer sent over. And the buyer now starts the timeline of paragraph 6B, where now the buyer has 3 days to decide how they want to proceed in this transaction. Do they want to accept that that seller is not willing to do anything? Do they want to back out because of something they found that they just have a non-negotiable? Or is there going to be an opportunity in these 3 days to have some better communication and come up with some sort of middle ground? These 3 days are when you get to decide to do that, and your final decision must be signed, mutually accepted by that 3rd day, or the buyer waives their inspection contingency and that transaction moves forward. All right, negotiations are done. Now, if both parties agree on a repair, there is a timeline obligation in getting those complete. In the boilerplate language, it gives 3 days prior to closing. And as most of us know, 3 days is a very unrealistic timeline when it comes to our buyers having the right to go back to the home and re-inspect the work that was done. So please consider changing your timeline in line 71. Buyers, you do have the right to go back in and re-inspect the repairs requested. This re-inspection needs to be done by the inspector or the specialist who called out those repairs. If you have an inspector that you sent through, you took a list of their repairs, ask them to be finished. In order to call out the non-completion, I don't know how else to say this, if the seller did not do what they were supposed to do, and you're trying to call that out, you need to do everything you can to follow your part of the contract, buyers. And that means getting the home inspector or specialist back out there to be the one to call it out. Now, we know that this timeline is realistic because we also need to, or unrealistic, because we also need to provide proof of completion to escrow. So we want to give escrow potentially invoices to prove that this is done, because sometimes these invoices need to go back to the buyer's lender. So the buyer's lender knows that these items have been finished. If you're working with a lender that's called out a work order, it's not going to be on this necessarily, but that work order would be a similar situation where you'd want those repairs to be done soon enough where it doesn't have to extend closing. Now, if you have a fast closing, it may be far more effective for you to ask for concessions rather than an item to be repaired. Concessions are also much easier to keep that seller obligated to perform in the contract. And once we start writing up words, we start writing up these repair words, we're going to find ourselves potentially leaving loopholes, potentially leaving room for misinterpretation. Now, a home inspection is not a septic inspection. It's not a well inspection, and it is not a perk test. If there is a septic system, you're going to want to include the septic addendum that gives your buyer the right to inspect or have it inspected for those systems. All records are public, so you can still see all those public records, but if you want to inspect any sort of system that is not just a general home inspection, you need to include the proper form. It is not included with this form. Are you reviewing the neighborhood? And if so, what exactly are you advising your clients to review? Be careful on this paragraph because we don't want to be encouraging any violation of fair housing. But if your buyer has questions about things like where the schools are, how the traffic patterns run through, what kind of noise happens here, what sort of surroundings might affect their use of this property, they may want to review the neighborhood. If they have questions about things like crime, we can point them towards a crime map or a website, but we should not be advising them or feeding them information about anything like that at all. So again, this contingency defaults to 3 days. And if no response is given for the neighborhood review contingency, then that is also seen as an acceptance and moving forward from those 3 days. So we have a lot of situations come up where a pre-inspection has been done and the buyer wants to waive the inspection, or maybe they want to waive it, but they want to ask for something that was found on there to be fixed. If you are waiving a home inspection, make sure you are advising your client. First of all, it's not advisable to skip a home inspection. But if your buyer does choose to do this, let's be in the habit of putting in the 35W in the contract, because this shows us several different things. One, if a pre-inspection was done by the buyer, it shows that the buyer did take that opportunity to do that inspection. Number two, if the buyer chooses to waive the home inspection, it's a box that tells that buyer, hey, you are waiving this home inspection, even though you do have the right to conduct this. It takes some of that responsibility off of our shoulders and puts it back on the buyer. This form also gives the buyer the right to ask for repairs if an inspection has been provided to them. We can write those repairs requested in paragraph 3. And what it does for this form is it continues the idea of the 35R in the fact that it gives a timeline for completion and buyer rights to make sure that that work got done. So again, if you're doing pre-inspection, anything other than an inspection contingency, highly recommending using the 35W. So you're either going to have 35 or 35W in your contracts. I just pulled up the sewer inspection. This is not, this would be if you are waiving a home inspection or waiving, doing a pre-inspection or something else that has nothing to do with sewer scoping, but you want to do a sewer scope. There is a sewer scope form. So if no home inspection is being used, you can go ahead and just do the sewer scoping in its own. Really quickly, I wanted to just talk about computation of time, thinking about these timelines. Remember, anything 5 days or less is business days. 6 days or more is calendar days. So if mutual acceptance is on a Friday and the home inspection contingency is 5 days, we're going to skip Saturday, Sunday, and we're just going to go Monday, Tuesday, Wednesday, Thursday, Friday. So they will have 7 calendar days if it is a 5-day contingency. Mutual acceptance is on Friday. Inspection contingency is 10 days. We're going to count all calendar days. So there'll be Saturday, Sunday, Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, Monday. They'd have till Monday. These computation of time, this is a very important thing to practice. If you are not completely comfortable with how this is done, let's practice. We have TCs who will also keep us on schedule when it comes to our computation of time. Just some things to think about. What if the buyer has an inspection contingency? Seller has not demanded a copy of the report with a 35C, and then surprisingly the buyer terminates. Can the seller just get the report still? Or if 35C is sent by the seller with the box marked for a full copy of the report and the buyer, does the buyer have to deliver the report? What if the inspection is delivered without consent? And the home inspector, actually had this happen once, the home inspector feels an obligation or a liability that they don't necessarily want that report shared with other parties. Does that home inspector have a right to keep that report from certain people or anybody other than their buyer?
No, it's the buyer's. The buyer purchased it, so it's their report, correct?
Absolutely. You're 100% correct. So,
That being said, for those people that aren't aware of this, sometimes you'll have a listing and you'll realize that like somebody else had done an inspection on it, and a buyer's agent will call and assume that they can just have a copy of the report. We don't, as agents, have permission to just give reports away. They belong to the buyer. They purchased it. They're the one that hired the inspector. So best practice is we have to get permission to forward it anyhow.
yes, thank you. I love that you're talking for me. I love it. Thank you. So yes, with the 35C and the termination, if there's no demand put in before that termination, unfortunately, the seller doesn't, or the buyer doesn't have to provide that. You can ask nicely and hope you get it, but buyer does not have to deliver that. Now, if the demand is made, once that demand for that report is made, the buyer does have an obligation to give it to you. So it's no longer a request, but rather an obligation. Now, if the report is delivered without consent, if there's no consent whatsoever for this, then unfortunately, the buyer did waive their right to keep that home inspection contingency. There may be 0 portions given, not one single page. Do not copy paste verbiage. Do not give anything that could be interpreted as a portion of the inspection report. And This was a surprise. I had a contractor give a bid, but in their bid, they labeled their bid inspection report. So we actually had to have them change the words in their bid because it made it seem like they were giving their inspection and not a bid. So please be careful in delivering anything and read everything before it gets sent over, because once you send it, it is done and you cannot unsend it. As far as that obligation or something that the inspector doesn't want anything shared, once that inspector sells that report, effectively sells that report to the buyer, the inspector can't really care about what happens to it beyond that point. They need to have everything in that reflects how they truly think about this. And if they don't feel that way, they shouldn't have provided the report to their client in the first place, because if that client chooses to share it, the word is out. A couple other things to think about. What if the inspector is the one that sends the report? It's happened. An inspector sends the report, and unfortunately, they CC the wrong people. What if the seller gives the report with consent, and then the seller's like, I don't want to read it. I don't want to know what's in it. Or what if the buyer checks the box to consent to see the report, and the seller does not want to see it at all? Kind of like the same thing as the question before that. If that inspector accidentally sends it to the wrong person, unfortunately, like I said, you can't unsee things. As if the seller receives the report and wants to pretend they didn't see it, they can't pretend that they don't know things that are on it. If they were accidentally given that report and they're like, I don't want this to waive the inspection, I'm just going to pretend this never happened, they can say that all they want. They can actually choose as a seller to just move forward with their inspection contingency for that buyer and not exercise that right to waive it, because truly this is a conversation between buyer seller. We're just stating what the contract says, right? But they can choose not to see it. That doesn't mean they can't deny facts that are in it. So if a Form 17 needs to be written later on down the line because this buyer backs out, then they can't unknow the things that they are supposed to know by receiving it. And if they're delivered the report, they're effectively in receipt of the knowledge that is completely within that report. Thank you for bearing with my lack of voice today. I really appreciate that.